Bright Duty. Every student matters.
Hello students, today once again I am here with chapter number 15, the Judiciary. All about this chapter is rule of law, what is independent judiciary, reasons why need an independent judiciary, provisions of ensure independence, composition, jurisdiction and powers of the Supreme Court, then Supreme Court's power of judicial review and how it is playing the role of guardian, final interpreter of the Constitution, judicial activism, composition and organization of the High Courts, jurisdiction and powers of the High Court and High Court's power of judicial review. Judiciary, it is that branch of the government that interprets the law, settles the disputes, and administers the justice to all the citizens. The judiciary is considered as the watchdog of democracy and also the guardian of the Constitution. For democracy to function effectively, it is imperative to have an impartial and independent judiciary. Indian administration guided by three pillars: legislature, executive, and judiciary. And Indian judiciary, the other organs of the Indian judiciary. In India, we have an independent judiciary, and the other organs of the government cannot interfere with the functioning of the judiciary. It is an important topic which we are going to discuss today. Like as you could see on the slide, the judiciary is the system of the courts that interprets, defends, and applies the law in the name of the state. The judiciary can also be thought of as the mechanism for the resolution of disputes. Let's start with rule of law. What is this rule of law? The ordinary meaning of the rule of law is the supremacy of the law. And it is the mechanism, process, institution, practice, or norm that supports the equality of all the citizens. In Law of Constitution, written by Dicey, this is a book where he says there are three aspects of rule of law. First one is your supremacy of law, where he says, while discussing the meaning and the first aspect of the rule of law, he stated that a man may be punished for breach of law, but he cannot be punished for nothing else. Thus, the meaning of the rule of law is that until and unless it is proved by the general rule of law of that country, and that a person has committed an offense, he cannot be punished. And next is with the equality of the law, equality before law, and secondly by rule of law. Dicey argued that equality before the law of the equal subjection of all classes to the ordinary law of land administered by ordinary court. Now, while discussing these aspects of the rule of law, Dicey clearly stated that with us, every official from the Prime Minister down to constable or a collector of a taxes is under the same responsibility. Then the legal rights are guaranteed by the ordinary laws and judicial decisions. So that means, according to Dicey, the legal rights of the British citizens or the any other citizens, such as freedom of speech, assembly, formation of institution, etc., are not specifically enumerated as such in the Constitution. But such rights are guaranteed there through general laws and judicial decisions. Hence, every victim can go to the court of law against the accused to redress this complaint against him. Now, what is an independent judiciary? As I said, India has an independent judiciary. What allows the judiciary to act independent presidential and congressional influence? Lifetime appointment for all federal judges can enhance PA's legacy. Cannot have salary reduced, can only be removed by impeachment, 7 in US history, can be impeached for unacceptable behavior. Now, what is this? What exactly this independent judiciary is? It means that judges must be able to discharge the powers and duties to their office without fear or favor. Now, why do we need this independent judiciary? What is the reason behind that we need it? Now, what is the reason that we need an independent judiciary? what is the like we say the background of this. So we say that this needs because it resolves controversies. It is resolving conflicts to protect fundamental rights. Let's start with the results of controversies. Like in a democracy, the independent judiciary finds very prominent role since it protects the liberty of the citizen. In our society, disputes are bound to arise between individuals, and if I say between groups and between individuals or groups and government, and all such disputes must be settled by an independent body in accordance with the principle of the rule of law. Now there are many more reasons like why the judiciary is free. Like first one is your resolving controversies, and controversies among different wings of government. Like constitution is supreme in our country. This is all everyone knows this, and this is all clear also. So all different wings of the government are assigned different powers as well. So only those powers are exercised by the judiciary which are listed in the constitution. But despite of all this, due to like ambiguity in this regard, it is but natural to arise controversy among all the wings of the government. So hence it is desirable to have impartial power and freedom to remove all such controversies while explaining the constitution. This function cannot be done by any other wing of the government than the judiciary. Now, resolving conflict between center and state, as I wrote it, it resolves the conflicts also. Like as we have read in the earlier chapters, also like there are so many conflicts between the state and the center. Few of the center powers are demanded by the states as well. So, federal government was established in our country under which powers were distributed at different levels, central, state, and local. So it is but natural that there may be conflict between the jurisdiction of powers among states and the center. The judiciary is capable enough to remove all such conflicts and controversies by explaining the constitution. Now, the next one is protecting fundamental rights. Now, how does it protect the fundamental rights? Under the Part 3 of the Constitution, fundamental rights of the citizens of India are enumerated, and it is always desired to uphold the dignity of these basic rights. In case they are snatched as diminished, or this function can only be exercised by judiciary. And thus, Indian Constitution has assigned the role of protection of fundamental rights of citizens to the judiciary. So, what it concludes. As see on the screen is written, the justice is often depicted as a goddess who is blindfolded and is not able to see whether people in the dock are highly placed or the lowly ones. She holds in her hands evenly balanced scales. That means the law is one and all for everyone. It never sees whether the person is rich or poor, as she holds in her hands evenly balanced scales and gives her judgment impartially. So, therefore, impartiality is the salt of justice. So the court not only prohibits the encroachment in the jurisdiction of various other agencies, but also fixes the limits of their jurisdiction and establishes the rule of limited governance in the country. In this chapter, the role of judiciary, its importance, the Supreme Court of India, the judicial system of our country will be discussed. Now, the provisions that ensure independence of judiciary in India. What are the provisions which are ensuring us the independence of this judicial system? The Constitution of India. It has ensured independence of judiciary by protecting salaries and services conditions of judges, prohibiting the judges from carrying on practice in courts of law after retirement, providing single judiciary. So these things make it independent. It gives an assurity. Now let us talk about the appointment of the judges first. In India, A person shall not be appointed a judge of Supreme Court unless he is distinguished jurist or has been a High Court judge for at least 5 years or an advocate of a High Court for at least 10 years. So the judges of the Supreme Court are appointed by the President. They neither political bias nor personal favoritism and would play any part in the appointment of judges. Although the charge of political interference was leveled against the central government at the time of senior Supreme Court judges resigned from their posts, and still the system of appointment of judges in our country is very good. And it from the post and ensures the appointment of the ablest person on one hand and avoids all types of political interference on the other. And it is exercised, it becomes a point of criticism everywhere in the country. Now, the salary and the allowances. How the salary and allowances of judges are given. The salaries and allowances of judges are drawn from the Consolidated Fund of India. Secondly, the terms and conditions related to their salary decided at the time of judge appointment can't be altered or negative side. Thus, the Supreme Court judges can take impartial decisions and without any fear, they favor of the Council of Ministers. Or procedure for removal. Although the Parliament can remove the judges of the Supreme Court, still it requires a majority of the total strength. And of both the houses of Parliament and at least two-thirds of the members attending the House, thus it would be very difficult to remove a judge for a cause other than his misconduct and disqualification. Now, what more point is there? That security of tenure. Tenure plays a very vital role in the efficient functioning of the judges. A very short tenure hinders the efficiency of the judiciary. On the other hand, if the tenure is long, that would give the judges an opportunity to understand the intricacies of law. In India, a Supreme Court judge can remain in office till he has attained the age of 65 years. And there are many more provisions also, like no discussion with the respect to the conduct of any judge and no controversy over its functioning. The Supreme Court has full powers to make laws for its functioning. They can act independently without any outside pressure. Then they have some executive powers also. The Parliament can't discuss the sections of the judges and done by them by discharging their legal obligations, and the Supreme Court is competent through the employees of legal cell, and it is at full liberty to do administrative and other arrangement. Then power to penalize for violation, and that is also, the Supreme Court is fully independent and free since it has powers to penalize for violation of law. And hence, if any person does not uphold the dignity of law and judiciary, he may be penalized by the court. He has to pay the fine. It is only decided by the court whether the person concerned has violated any law or not. And on 6 March 2002, the Supreme Court penalized Arunadhiti Roy for contempt of court, because genuine criticism of judgment is allowed, but nothing should be done to lower the authority or dignity of the court. The Supreme Court or the High Court has the power to punish for contempt of. Now, whom the judges are accountable to? Like, independence of the judiciary does not mean the judgments were given quite arbitrarily without any plan or system. All three organs, like executive, legislature, and judiciary, should work in accordance with constitutional provisions, and their judiciary should work in accordance with constitutional provisions, and they should interpret the law in a manner consistent with the basic structure of the constitution. Democracy, secularism, and federalism are considered as basic features of our constitution. Finally, as Justice Krishna Iyer once said, the most sacred obligation of the judge is to dispense justice to the downtrodden section of the country. Now, Let's talk about the composition of organization of the Supreme Court. Supreme Court at the time of inauguration of Constitution, the Supreme Court consists of one Chief Justice and seven other judges. Presently, the Supreme Court consists of Chief Justice and 30 other judges. Now, let's talk about this composition, how the Supreme Court was composed and how it started working. The Constitution of India and is the supreme legal document. We all know this thing of the country, and there are various levels of judiciary in India. Different types of courts, each with varying powers depending on the tier and jurisdiction and bestowed upon them. So they form a strictly hierarchy of importance in line with the order of the courts in which they sit, with the Supreme Court of India at the top, followed the high courts and of respective states as well. The appointment of judges has never been free from political controversy. It is a part of the political process and it makes a difference who serves in the Supreme Court and High Court, the political policy, philosophy of the judges. Thus, views about the active and assertive judiciary or controlled and committed judiciary have an impact on the fate of legislature enacted. In fact, everybody, that includes Council of Ministers or Chief Ministers and Chief Justice of India, influence the process of judicial appointment. Now, who appointed the Chief Justice of India? I talk about Chief Justice of India, highest ranking judge. And thus hold the highest judicial position in India. So generally the most senior in the Supreme Court is appointed by the president. And however, this convention has been breached on a number of occasions, most notably brings uh, during the prime ministership of Indira Gandhi, when A.N. Ray was appointed as the Chief Justice, despite three judges being more senior than him. It was alleged that Ray was appointed because he was considered to be supporter of Gandhi's government during a time when her government was becoming increasingly mired in a political and constitutional crisis. Now, the qualification for appointment as a judge, how these judges are being appointed, on which qualification, on what basis. They must have been worked for at least 5 years as a judge of a high court or an advocate of a high court for at least 10 years, must be in the opinion of the president a distinguished jurist. And oath of the office. Every judge, before he enters upon the office, has to make an oath or affirmation that he will bear uh, true faith and allegiance to Constitution, will uphold the sovereignty and integrity of India, and will perform the duties of his office without fear or favor, affection, or it will. The oath is administered by the President of India. The removal of judges, a big question. How they are being removed? It's not so easy task. It is very difficult. Now, next is removal of judges. How these judges are being removed? The removal of judges of the Supreme Court and the High Court, they like is also extremely very difficult work. A judge of the Supreme Court or High Court can be removed only the ground of proven misbehavior and incapacity. That means if they prove their misbehavior and misbehavior or incapacity. If they're incapable of doing something, if they're misbehaved people, if both the houses uh, of the parliament pass the non confidence motion of the two-third majority for his misconduct, or the disqualification. And this motion is also proved, by both the houses of the parliament. He may be removed from his post. When the parliamentary discussion, such motion against a judge is proved, his concerned judge is entitled to be present in the house to present his case before the house. And it is very clear from this point that the removal of judge is a very difficult task. It is a very difficult procedure. Why so? Unless there is general consensus among the members of the parliament, a judge cannot be removed. Here is an interesting point. While is making appointments, the executive plays a crucial role, and the legislature has the powers of removal. So this distribution of powers ensured the independence of the judiciary. Now the jurisdiction and the powers of the Supreme Court. The Supreme Court has also a very wide appellate jurisdiction over all courts and tribunals in India, inasmuch it may, in its discretion, grant special leave to appeal under Article 136 of Constitution from any judgment, decree, determination, sentence, or order in any case or matter passed or made by any court. So let's talk about Supreme Court. India is a very vast country. The Supreme Court has also a very wide appellate jurisdiction over all courts and tribunals in India, and as much in it may, in its discretion, grant special leave to appeal under Article 136 of Constitution from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court. Jurisdiction of Supreme Court, like powers, which are three in number: original jurisdiction, appellate jurisdiction, advisory jurisdiction. Original jurisdiction cases brought directly, and it happens if disputes between union and the state government or between state government, violation of constitution of government or individual, or violation of fundamental. An appellate jurisdiction is like court hears the appeals against the judgment of the high courts. An advisory jurisdiction advise the president on legal matters and constitutional issues, functions of the court of records. Now let's read all these jurisdiction and powers of the Supreme Court in detail. The Indian Supreme Court is vested with very wide powers, and when compared with the Supreme Courts of the other countries, the Supreme Court of India has enormous powers. Here you could see the first one we are going to do original, then advisory, and appellate. The original jurisdiction, those cases which are directly filed, are directly filed cases. Then, under this jurisdiction, Supreme Court settles the disputes. Here, Supreme Court is the one who settles all the disputes between union and states and among states. And then generally, the reasons are a case in which on one side Indian government and the other side one state government. That means central government or state government disputes. Then a case in which on the one side of Indian government and one or more states, that means states are also involved, many states, and on the other side one or more states, government of union are parties. And then a case in which one or more state of Indian Union parties are there. So original jurisdictions are settled by Supreme Court, and Supreme Court never wants that writs for the enforcement of fundamental rights are to be used, and government of India and any state versus other states between two or more states. So Supreme Court never wanted or never wants these disputes. So when these cases come directly to Supreme Court, they give the judgment. Then appellate jurisdictions. Appellate jurisdictions are court of appeal in one which may change the decision or reduce the sentence passed by the lower courts. So in addition to regional jurisdiction, Supreme Court heavy, and it can change the appeals against the decisions given by the High Court. That means if High Court has given any decision, Supreme Court hears it. And it is also white. Supreme Court is white. Why it hears? Because it could be the interpretation of Constitution. It could be a civil case or a criminal case, and it could be a special appeal. Let's see how. When interpretation of the Constitution is there, means the most important function of the Supreme Court, and it is to give to the clarity to the provisions of the Constitution to interpret them. And Article 132 lays down that an appeal shall lie in the Supreme Court if the High Court certifies under Article 134A that the case involves a substantial question of law as to be interpretation of the Constitution, then such an appeal can be heard in the Supreme Court. Next are the civil cases. How the civil cases? An appeal shall lie to the Supreme Court for any judgment and in a civil proceeding of a High Court. If the High Court certifies that the case involves a substantial question of law of general importance, and in the opinion of the High Court, the said question needs to be decided by the Supreme Court, then such an appeal can be entertained by the Supreme Court. Then the criminal cases. Appellate jurisdiction of Supreme Court against the decisions of a High Court in regard of criminal matter can be divided into two parts: without certification, with certification. An appeal without certification is like if the High Court on appeal reversed an order of acquittal of an accused person and sentenced him to death, or if the High Court has withdrawn for trial before itself from any court subordinate to its authority and has in such trial convicted the accused person and the sentence him to death. Then with the certificate of High Court, if the certificate is there of High Court under the Article 234C that the case is a fit one for appeal to the Supreme Court, then the appeal would be made. Special appeal, special leave, that means the Constitution gives a very special kind of power to the Supreme Court. But Article 136 provides it. And Supreme Court in the form of judiciary powers different from the common law. And according to this provision, the Supreme Court may, in its discretion, grant special leave or to appeal from any judgment, decree, determination, and sentence or order passed by any court in the territory of the India. And there is only one exception by this unlimited powers of the Supreme Court, that this is the military court and whose decision appeal cannot be made. Now let's move to advisory consultative jurisdiction. That means power of President to consult Supreme Court. Under Article 143, Article 140, the President wants to seek the advice of the Supreme Court on some questions of law, and then the Supreme Court has the power to give advice. And after due consideration on the matter, the court can send in advice and to the President, which is in the clause number 2. And this article states that if President under article number 131 seeks advice on a matter which is not written the jurisdiction of the Supreme Court, the court shall have to give its advisory. And writ jurisdiction, enforcement of fundamental rights. The Supreme Court is the guardian, the responsibility of protecting the fundamental rights rests on the shoulders of the Supreme Court. If the government plays the fundamental rights of the citizens, then they can seek protection from the Supreme Court. The letter gives protection of these rights through the various constitutional remedies, and the Supreme Court is the protector of fundamental rights. Any citizens whose rights have been violated may have the move to Supreme Court for the enforcement of the rights. The Supreme Court has power to issue orders or writs in nature of habeas corpus, mandus, prohibition, quaterantio, and praetora for the enforcement of any of the fundamental rights. Now, the advisory jurisdiction. There is a case study. In the past, the president had to be seek Supreme Court opinion in several matters. In the 1967, the president obtained the opinion of the Supreme Court of Kerala Education, and temple originally existed at the same site when the Babri Masjid subsequently stood. The Supreme Court declined to report to President its opinion on the controversial Ayodhya dispute. And on July 27, 1998, President sought the Supreme Court's opinion on some question with regard to the High Court judges transfer from one court to another. Supreme Court is a court of record as well. The Supreme Court is a court of record. How? Like it is one whose judgments are recorded for evidence and testimony, and they are not the question when they are produced before any court. And the judgments are in the nature of precedents. The High Court and the other courts are bound to give a similar decision in a similar case. Then the second part of the article says the court has the power to punish contempt of itself.